reserve 4 minutes for rebuttal.
That'll be fine.
Here for the appellant, defendant, wife. The most important fact in this case is the length of the marriage. The parties were married in October of 2015. Date of divorce is June 2023. Date of separation, notably, is July 2021. So we have a almost 8 year marriage, a 5 year, 9-month marriage if you date it as the time of separation. The second most important factor is the disparity of the assets of the parties. My client's assets at the time of the marriage were approximately $12,000 to $17,000, and she was unemployed at the time of the marriage. The husband had well in excess of $1 million of assets, owning 2 companies, which I'll detail in a second. So we have this balancing act that has to occur, and I'll get into more detail in a second. The weight of the contribution of the wife, tangible or intangible, and the length of the parties' marriage in the face of the well-settled law that we have a short-term marriage and the parties are to be returned to their positions as close as possible to when they entered the marriage. So does it even matter what the wife contributed to the marriage, tangibly or intangibly, if it's just a matter of what did the parties have when they came into the marriage, and that's all they deserve to leave the marriage with. Doesn't matter if it's a 1 or 2 year marriage or a 5 or 6 year marriage or a 6 or 7 or 8 year marriage. If it's defined by the trial court or by this court to be a short-term marriage, then are we just stuck with this resolution that we just have to put the parties as close as we possibly can to what they came into the marriage with? Is it important that this marriage dissolved when the husband attacked or assaulted the wife that resulted in an order of protection? She didn't want the marriage to be over. He came home from church. They got into this argument. It rose to a level where the chancellor granted an order of protection to the wife, and then the separation ensued. She didn't want to be divorced. Husband sued wife for divorce, and ultimately wife was granted to divorce. So all that she had contributed to the marriage, tangibly or intangibly, does that go out the window, and are we just left with this short-term marriage definition? Notably, in this case, the husband had Parkinson's. He requested his wife, to not work, to not return to work, to take care of him, to stay at home, and then to work in his 2 businesses. He had 2 businesses at the time of the marriage. He owned a golf cart company, and he owned a warehouse company. During the course of the marriage, wife worked in the golf cart company. That was then sold, and then wife worked in the warehouse company. It's also important to note that these parties just didn't run into each other at church, date for a couple months to get married. They knew each other for a long time before, had lost contact, so they had a friendship for many, many years, though long ago, and then they met. And again, husband had Parkinson's, the parties got married, and he asked the wife to not return to work and to take care of him. Then, as I've already noted, about the demise of the marriage. Wife.
Is that part of the record? Because I don't remember seeing that in the final order of the memorandum that the trial judge.
That the husband had Parkinson's?
And that he requested her to stay at home and take care of him.
Yes, that's in the record. That's what the husband testified to, and that's what the wife testified to. Wife was age 56 when they got married, and again, she had left her job as a bookkeeper and wasn't currently working at the time, but then she got to be 63 all during the course of the marriage, so she lost those years of employment, years of increased Social Security earnings, years of employability to, again, stay at home with husband, work in his businesses. They bought he had the farm before they got married. They refinanced it, put it into her name, so they acquired this farm together, and she had animals, and she took care of the farm and took care of him. And again, that farm became a marital asset because it was transmuted, and it was over $400,000.
Excuse me for interrupting, counsel. Was there a Rule 7 table of assets filed in this case?
Yes, we filed with the court appendix to the brief, and it details what I believe purports to Rule 7, Your Honor, and it goes through each item of property, appellate's value, value found by the court, and who was awarded to, and gives some summations. There were some missing items that we detail also that the court never valued. I'm not I don't think that's substantive or persuasive in terms of doing anything different as a matter of some personal property, but I do think that will be informative to the court. When you look at our brief, we cite some numbers, and obviously numbers can be deceptive, but it's 91% of the marital assets went to husband and 9% went to wife. Well, technically, after the husband's mortgage is included, or the mortgage that went to husband, wife got about 23% of the assets that were marital, and husband got 77. Now keep in mind, husband is still a millionaire, so his assets, separate assets, are $1.4 million, and my clients are far less than $100,000, as detailed in our brief and in husband's brief.
You came into this marriage, though, with far less access, didn't you?
No doubt about it. During the marriage, she received a gift, an inheritance of $56,000, it's in the record, and $40,000 loan. Well, she purports it to be a loan from her sister in order to get through the separation. And so, yeah, her assets leaving the marriage were somewhere, less than $100,000, maybe around $50,000. So, I mean, she didn't leave the marriage with much more than she came into it with, but she came into it with $12,000 to $17,000, and certainly the husband left with in excess of $1.4 million. So he wasn't harmed by the marriage. So, but that's, I guess, my next point was, where is wife when she filed for divorce or left the marriage? I mean, where is she in her ability to acquire future income, future assets? She's now 7 years older. She has minimum assets. She has no real property, and she has to leave this marriage, and the husband has, again, so much money. So she came into marriage, she took care of husband, she worked in his businesses, she wanted to stay married to him. Now they're divorced, and after 7 years, she's back where she started. And she's not 23, now 30, or 35 to 42. She's a 56-year-old woman, now 63 years old, and not been employed for that entire length of time other than working in husband's businesses. So,
was your client employed when she met?
She was not employed.
She had voluntarily quit her job as a bookkeeper, is that right?
Yes. She was not employed at that time. She was, I would say she was in between jobs.
In between.
But yeah, she wasn't employed.
My father-in-law used to refer to it as Mike's temporary transitional unemployment.
Well, that's where she was, Your Honor, not employed. And then she met, I mean, everybody agrees what happened. She met him at church. They fell in love. They had a quick romance. They knew each other for a long time ago. They got married, and again,
Was she not compensated for working in her husband's business?
for a period of time, she was paid $1,500 a month for different periods of time, specifically at the golf cart company before it was sold. I don't think she was specifically compensated at the warehouse company. So the issues that we raised on appeal is, did the court err dividing the marital estate pursuant to 36-4-121? Specifically, was there an overemphasis on the one factor of the length of the party's marriage? And just because it's the first factor doesn't mean it's the most important factor. All the factors have to be given different weights depending on the evidence and the circumstances that present themselves at trial. Again, as I started in this case, we all know how long the marriage is. That's just plain math. The question is, how does that comport to balance out with all that the wife did contribute and all that she did give up, as well as the significant amount of separate assets that the husband had? I mean, if he came into the marriage as a millionaire and she came in with next to nothing, she did everything that, quote, she was asked to do during the marriage, take care of him, work in the different businesses, take care of the farm. He put the farm in both names, and then she leaves the marriage with, essentially next to nothing, which is what she came into the marriage with. Is that how this law is supposed to be applied to this fact pattern? We think that the court put too much emphasis on that one factor and left my client, again, with de minimis in terms of the division of assets. I mean, she got 23% of the marital estate, plain and simple. The length of the transition alimony that was awarded, she clearly was found to be a disadvantaged spouse. She was awarded $25,000 to be paid over 12 months to compensate her purportedly for her interest in the farm, and then she was given $1,500 a month for 6 months. Now, the court does go to great lengths to say, well, you lived in the house for a year and a half or 2 years while this case was pending. Why didn't you go get a job? Why didn't you do anything? So that was part of the court's analysis. But here she is waiting to be divorced and waiting to be divorced, and she gets divorced, and the court says, you got 6 months to be out of the house, and I'm going to give you 6 months of this transitional alimony, and then you're on your own. And the only asset that you're really given is, $25,000 that's going to be paid over 12 months. So certainly she left the marriage gaining nothing. And back to my original point, does what she contributed to the marriage, tangibly or intangibly, even matter? The other issues raised on appeal are attorney fees. Should she have had to pay her $23,000 of attorney fees when she was awarded the divorce? Didn't want to be divorced. He sued her for divorce out of her separate property, or not her marital assets, because she didn't really have any, certainly didn't have anything liquid to do, so she'd had to pay out of her loaned money from her sister or the $56,000 that she inherited. So she'd have to decrease her assets in order to pay for her attorney fees when the husband had such significant assets. And then again, now we're on appeal. The issues raised by husband, or should she even gotten the $9,000 that she got, and should she have to come to this court, pay for additional attorney fees in order to get what she should have been entitled to under the statutes 36.4.121 and 36.5.121. I'll save my time for rebuttal.
Thank you. Hear from the appellee.
Good afternoon. May it please the court, my name is Jeremy Cawthorn. I'm a shareholder of Patrick Beard Shulman and Jaycoy in Chattanooga, Tennessee. Our firm represents David Ashley Leonard in this appeal that has been instituted by his now ex-wife, Kimberly Champion Leonard. Now, Ms. Leonard requested their last name be changed, and it was adopted by court order, so I may refer to her as Ms. Champion. So Ms. Champion in her appeal takes issue with every conceivable aspect of the trial court's judgment. This is not an isolated rifle shot where Chancellor Bryant, there's an allegation that Chancellor Bryant missed something nuanced or specific. It's everything. After 2 days of trial, the appellant claims she missed everything, and that's not the case. Ms. Champion's appeal does not find its grounding in legitimate factual disputes or fine points of law that were arguably misapplied by the trial court. Instead, Ms. Champion's appeal finds its fuel in her frustration and disappointment that the trial court, after 2 days of trial, did not award her the life of leisure that she demanded. But her frustration and disappointment with the trial court's decisions, which terminated her short-term and later-in-life marriage to Mr. Leonard on equitable terms, does not equate to what a meritorious appeal. What Ms. Champion is asking this court to do is to revolutionize what the appellate process is. Wants to revoke the trial court's discretion and wants to supplant this court's discretion and institute a de novo appeal type where we have a reweighing of the evidence in this court. And that's an invitation that this court and the Tennessee Supreme Court has declined time and again in divorce cases. There were series of factual issues that were raised during the argument. There's a number of disagreements we have, but I think that we need to register for disagreements. One is there was an argument about an assault. There was evidence that there was a dispute at the farm. There was an order of protection, which was part of the court record. But upon hearing the evidence at the trial court, Chancellor Bryant concluded she was uncertain what happened that day. She was uncertain exactly who was at fault, but concluded that she believed that Mr. Leonard to primarily be at fault. Two of the witnesses, both at the order of protection and at the trial, were provided with $6,000 by Ms. Leonard. and they testified favorably, but as Chancellor Bryant found, inconsistently with one another. There was an allegation that Mr. Leonard requested for Ms. Champion to stay at home and forego employment. That was disputed. Mr. Leonard denied that being the case during the trial. And I don't think this court has to look much further than this. Ms. Champion said she wanted to work, and it was Mr. Leonard who said, don't work. She was unemployed when they met, and she had voluntarily quit her job. And then over a 2-year separation, she hadn't made a single job application until the week or two before we had trial. And Chancellor Bryant found that that was unreasonable. She had squandered her opportunity to prepare for single life. And that's what Chancellor Bryant found. There was also an argument that Ms. Champion had contributed in a material way to the separate businesses. That was also rejected by Chancellor Bryant at trial. At the golf cart business, which had been sold during the course of the marriage, she was compensated $1,500 a month, which is also an indication that Mr. Leonard had not asked her to stay at home and not work. Ms. Champion claimed that she made a material contribution to Warehouse Way, another one of the separate businesses or separate assets of Mr. Leonard. Chancellor Bryant rejected the contention that she made a material contribution to Warehouse Way and found that the Warehouse Way remained Mr. Leonard's separate property. There is a suggestion that Chancellor Bryant and our position is that the short-term duration of the marriage is a controlling or a mandate for what curtails the trial court's discretion. That's not at all what we have argued, and it's not what Chancellor Bryant did. The linchpin for that argument about a purported inequitable division of the marital estate is that there was too much emphasis, which is code for too much weight of the evidence, which is Chancellor Bryant's prerogative, but too much emphasis on the short-term duration of the marriage. The Batson and Webb cases that we've cited stand for the propositions that it is in fact equitable to return the parties to their pre-marital positions if it's a short-term marriage, particularly a later-in-life marriage. But that's not what Chancellor Bryant did here. She awarded $28,000 from the marital estate, which eclipses Ms. Champion's premarital net worth of between $12,000 and $17,000, as Chancellor Bryant found, by somewhere between $16,000 and $11,000, depending on which side of the range you want to take it from. In addition to more from the marital estate than she brought in, Chancellor Bryant found that it awarded her $25,000 in alimony and solido for a portion of the equity from the farm. Chancellor Bryant found that Ms. Champion had made no contributions whatsoever financially to the marriage, hadn't made any financial contributions to the farm, and there was a significant argument about the non-financial aspects or contributions. But we need to look no further than the Batson Court of Appeals case that it's a reported case, and it identifies that in a short-term marriage, the non-financial contributions are of minimal weight, minimal significance. And what Ms. Champion contended with respect to the weight of her contributions or the non-financial, Chancellor Bryant rejected almost all of those contentions. She rejected those contentions at trial. There's a significant argument about what the husband brought into the marriage versus what Ms. Champion brought into the marriage. There's an argument that look at how much money Mr. Leonard has, look at his net worth. Of course, Ms. Champion should be awarded more. That's not the law. It's not the law. The instruction when we see Batson and Webb is to return the parties, and it doesn't matter if one party has significantly more than the other. This is not a time to take separate property away from somebody and award it. That's not what the law is. There was a claim that there was a $40,000 loan from Ms. Champion's sister to her during the duration. That was offered to Chancellor Bryant, and she rejected the contention that it was a loan. We contend that Ms. Champion is unable to identify a single instance of abuse of discretion by Chancellor Bryant. Mr. Leonard, however, has presented as a counter-appeal 2 meritorious issues on appeal. One is the award of $9,000 in transitional alimony to Ms. Champion. I'll address that in more detail momentarily. We also contend that this appeal is frivolous. Each of the issues that have been appealed were entrusted firmly to Chancellor Bryant's discretion. And the argument of improper weight on the evidence is an argument asking the court to reweigh the evidence at this level, which is improper. With respect to our contention about the frivolousness of the appeal, we're relying obviously upon Tennessee Code Annotated Section 27-1-122. As the Tennessee Supreme Court explained in Davis v. Gulf Insurance Group 546 Southwest 2nd 583, Tennessee Supreme Court 1977, successful litigants should not have to bear the expense and vexation of groundless appeals, nor should this court, which is becoming increasingly burdened by direct appeals, be saddled with such cases. The Tennessee legislature obviously intended the frivolous appeals statute to discourage such appeals and to redress the harm to harassed appellees. This court in Jude v. Guy, the 2015 Tennessee Court of Appeals, December 21, 2015, Court of Appeals held, notes that an appeal qualifies as frivolous when, quote, when it is devoid of merit, has little prospect of success, or is lacking in justiciable issues. The Davis court went on, defined these justiciable issues as, quote, recognizable on its face as devoid of merit when it presents no justiciable questions, neither debatable questions of law nor findings of fact not clearly supported. What you'll note in the entirety of the appellant's brief is it's about the weight of the evidence. There is no identification of a factual conclusion that it was devoid of evidence at the trial court level. There's no argument that the standards were inapplicable. What it is that the court weighed evidence in a way that Ms. Champion wishes the court had not weighed the evidence, which is in fact a frivolous appeal. We've cited the Williams v. Williams case about that, and this is a quote from the Williams Tennessee Court of Appeals 2008 case. The issues raised by husband on appeal are reviewed for an abuse of discretion, a notably high standard of review. Any objective review of these factors would cause a reasonable person to conclude that husband's appeal had no reasonable chance of success. And the court concluded so because each of the issues appealed were subject to the abuse of discretion standard and were firmly entrusted to the trial court's discretion. Mr. Leonard did not make Ms. Champion appeal this case. Mr. Leonard, I can assure you, would wishes that I was not here today. Ms. Champion chose, just as she chose not to seek employment at the income rate that Chancellor Bryant found, which was $800 net of income tax per week. The equitable division of marital property, as this court knows, for instance, Larson v. Ball 301 Southwest 3rd 228, pages 234 through 35, which ultimately is a Tennessee Supreme Court case. It says it entrusts the equity to the trial court. And I've already addressed some of the issues with there's no instance of a conclusion that has no evidence in the record. It's the weight. The linchpin of the argument is that there was too much weight put upon Batson v. Batson and Webb v. Webb and the short-term duration, but that's inaccurate because Chancellor Bryant recognized that she had discretion above and beyond the short-term duration of the marriage and the instruction to return the parties to their premarital state, because she awarded Miss Champion far more than the $12,000 to $17,000 that she brought in. You'll note that Mr. Leonard, despite the existence of Batson, Webb, and other cases, has not appealed the equitable division because it would have been frivolous to do so. That was Chancellor Bryant's discretion. She heard the evidence. She made the determination she did. Chancellor Bryant also expressly found that the proposed division of the alleged marital estate by the wife was unreasonable. The award of transitional alimony, the reason that we contend that was an error is that it was an illogical and unjust conclusion based upon the facts that she found. Chancellor Bryant found that she had that Miss Champion had an $800 net per week earning potential. She found she squandered her opportunity for 2 years during the state of the separation to obtain employment. She found that had she obtained employment commensurate with her earning capacity, she would have no need. And when you have those conclusions of fact, Miss Champion should have had no need at the time of trial. And the Mayfield, Tennessee Supreme Court case reversed to address the transitional alimony when someone was willfully unemployed. In order for this illogical and unjust result to stand, the court would have to sanction that a spouse can engage in rank gamesmanship by being willfully unemployed to create the illusion of need, and that the trial court can determine that the spouse engaged in such gamesmanship, but nevertheless can award a spouse transitional alimony based on a need that should not have existed, based on the trial court's findings of fact. And for the other issues, I understand I'm out of time. We rely on our papers. Thank you, Your Honor.
Thank you. Hear from the appellant in rebuttal.
Thank you, Your Honor. We filed a reply brief in this case detailing our response to the claims our appeal was frivolous, and I'll rely upon that, but I will cite the court to a case that we detailed and analyzed in our reply brief. Imposing a penalty for a frivolous appeal is a remedy which is to be used only in obvious cases of frivolity and should not be asserted lightly or granted unless clear application, which is rare. And so we would assert that to punish or just to start a standard of punishing a disadvantaged spouse for coming to this court saying, hey, the trial court got it wrong, the trial court abused its discretion, I was treated unfairly, and then assert that her appeal is frivolous would be outside the bounds of the law and the standards that have been applicable in these cases for decades. So we would ask the court to deny any claim of frivolousness. Specifically, to go back into the points that we were talking about when I started this conversation and address the husband's assertion that my client somehow got treated more than fair. Well, she was married for 7, almost 8 years, and she walked away with, by the math just asserted, $16,000 extra dollars, $25,000 for alimony, and $9,000. So she got $50,000 for being married for 7 years to this millionaire who asked her to marry him, and then she relied upon him and stayed married to him for that period of time until he did, in fact, attack her and did have an order of protection granted against him, and then did file a divorce against her and then tried to divorce her, and she was granted a divorce. She became reliant upon him and the standard of living, which is what alimony is intended to address, and if she became reliant upon him and he became reliant upon her because of his Parkinson's, and put a house in their joint names, and they lived together as man and wife for that period of time, certainly she is entitled to be transitioned out of the marriage and to know what that looks like when the court's going to make an award of division of assets. That's why the division of asset award happens first, and then the award of alimony. How was Miss Champion to know what she was going to be entitled to or what her life would even look like post-divorce until there was a divorce in this case? It wasn't her fault that it took so many years to get to the end result. So she became reliant upon this marriage. She had every right to do so, and then she gets left, as the math was just cited to the court, with $50,000 extra dollars for all of her trouble. So we would ask the court to go back into the briefs and back into the record and find that, yes, Chancellor Bryant abused her discretion. She put way too much weight on the fact that these parties were just married 7 years. It was a short-term marriage, put them back to where they were from before, ignoring all the other considerations. And so we'd ask the court to grant the relief as requested, specifically that the court divide the assets more equitably, given all of her contributions, and award her additional transitional alimony, award her attorney fees for the at the trial court level and attorney fees at this level. Does the court have any questions?
I
Thank you
hear
for your
none.
time.
Thank you. Thanks to both counsel for your oral arguments today and your briefs. Have a safe journey back south. Adjourn court until our next regularly scheduled docket.
All right.